section 7 in the last lecture. I want to discuss today section 8, which is not very important one for LLB purposes.
Sir, I have a question regarding section 7, sir.
Well,
Sir, during the last time you said that in the case of the George versus Layya, sir, it was said by the High Court that if custom and rituals are not followed and the marriage which has been made in their absence, sir, it would be void as per the George versus Layya case, sir, given by the High Court. Sir, when I referred some other case of the Supreme Court, sir, it was the case name is just a minute, sir. Sir, Shanti Dev Verma versus Kanchan Pramar Devi, sir. It belongs to 1991 Supreme Court Division Bench judgment, and in that case, sir, when I went through the case, sir, the court authoritatively mentioned that if customs and rituals are not followed, then in that case, the marriage would not be valid. Sir, but they never use the term void. So, sir, is it right that we only now write that particular Supreme Court authoritative judgment of the division bench, or is it still necessary that we mention these High Court demarcation as far as their
actually, this is the issue. Since it has not been settled down and the court has not categorically overruled, this is called as per curiam judgment. Do you know the meaning? Per curiam.
Yes, sir.
Per curiam means without referring the earlier judgment. If any judgment has been given, this is called as per curiam judgment. So, if this Rajoti versus Salaya, this decision has not been referred by the Supreme Court and overruled it directly, then we have to discuss all the aspects. This is called as per curiam judgment. Suppose it has been referred and overruled, then there is no need to discuss it. But since it has not been overruled or repealed by any law or by the Supreme Court judgment, then we have to discuss Rajoti versus Salaya.
It was mentioned in the Supreme Court case only, sir. The Supreme Court only gave this judgment. Just with the specific judgment. Shanti Dev.
Right, to understand what I am saying. I am saying actually any judgment which overruled the earlier judgment. Are you getting this?
Yes, sir.
If there is no overruling, then naturally that judgment stands even after that. So in this case, actually, in Supreme Court judgment, the Jyoti versus Salaya has not been overruled. That's why we have to discuss it. This is called as per curiam judgment.
Okay, sir.
Any more question?
Sir, could you please briefly define the difference between when a marriage is void? Sir, we know when a marriage is void, what will be the aspect when a marriage will be void. But sir, if it is not valid, then consequence, what the consequences of marriage not being a valid and consequence of a marriage being void? How they are different, sir?
Actually, if the marriage is not valid, this category has not been provided in Hindu law.
Yes, sir.
Hindu legislation, if you go, the three kinds of marriages are here, either valid or void or voidable. Okay? But a fourth category has been created by the court. And this category is like the category which is prescribed under the Muslim law of irregular marriage. So irregular marriage means irregularity has been committed, and this irregularity may be rectified later on. So here also invalid marriage means what? No doubt this is the marriage. But here it may be rectified. Are you getting this?
Yes, sir.
Oh.
So, sir, if it can be rectified, then it can only be rectified by further following those customs or rituals.
Yes.
So, sir, in that case, sir, if for example, if we contrast it with an example where a bigamy has been committed, in that case, sir, sir, it is void. I know, sir, it is the marriage in that case is void. But, sir, my question is that even in the case of bigamy, sir, the person can get a divorce from his first wife and then can marry the second wife. In that case, even then, that void marriage.
No. This is bad concept you have in your mind. When the marriage is void, there is no requirement of any divorce. Void means it is no marriage at all. Parties are free. They can marry with another person. Okay?
Okay, sir. Okay, sir.
Now, section 8, so far as the registration is concerned, I will take only 10 minutes to discuss it. Because actually, this is a provision which is provided under Hindu Marriage Act. And this provision actually why relevant? Because in some competitive examination, this may be asked whether the registration of the marriage is compulsory or not. Section 8 is very clearly stipulates that if a marriage under Hindu law is made, there is no requirement of any registration. It is as good as without registration or with registration. There is no difference. But here the provision of section 8 is given. Here, if you go through the line of the subsection 1, for the purpose of facilitating the proof of Hindu marriage. Only view as a proof for Hindu marriage, and here the state government is under the obligation to make the rule for entry of particular of that marriage in a register, and the register is called as the marriage register. So now here, first part is very clear. It only stipulates that the state may make the rules for entering the particular of marriage as the manner prescribed or with the condition prescribed. Only following that, it is a marriage. It is actually the registration is required. Now, the second subsection 2, again the power is given to the state government. The state government, keeping in the necessity or the expediency, the state government may prescribe registration of marriage within a state or the part of the state as a compulsory for all the cases or for particular cases. So this is also subsection 2, where the power is given to the state government. So when there is a necessity or there is an expediency, then the power is given to the state government. That is state government here, the state government, it may prescribe the registration of marriage compulsory, either within whole state or the part of the state, or for all the cases or particular cases. So here, this provision is being given, and if there is a requirement from the state government side, registration has made the compulsory, and if not registered, then here actually punishment is given, and this is very meager punishment of 25 rupees only. This is a punishment which is given. Now the third part, since the rule making power belongs to the legislature, therefore any which is made by the state government, it is required that this rule should be put before the state legislature. Why? Either a state legislature approve it or make the modification. So that's why here the third part of this section 8, what is required, if any rule is made, this rule should be put before the state legislature. Now, fourth part is actually effect is given. Suppose any entry is being here made in the marriage register. Now, that entry shall be treated as a evidence, and it is admitted before the court of law. Therefore, what lines is written here shall be admissible evidence of the statement therein. If it means that any statement which is given in marriage register, it shall be admissible evidence. Now, this register shall be open for inspection at all reasonable time, and a copy of the same can be obtained by paying the prescribed fees. So that's why this is fourth provision, which is stipulating very easily that inspection and a copy you may get. Now, fifth and the last, here, that is very important. Fifth one is very important. Why? Because actually, it is providing that if registration has not been made, omission in registration, and if there is a omission in registration, then validity of the marriage cannot be challenged on that ground. It means that whether the marriage is registered or not, whether particular of the marriage is registered or not, if that marriage is not registered, it is not going to be affected the validity of the marriage. Validity of the marriage is different thing, and the registration is different. Now I want to refer one case. The name of the case is Seema versus Ashwani, and in this case, Seema versus Ashwani. 1 minute, hold on. There are one. अरे उषा, कितना का नंबर आ रहा? Hello. One case I want to refer in this regard, that is the Seema versus Ashwani Kumar. Actually, in this case, the Supreme Court, this is the decision of the Supreme Court. This is very relevant to say here. And here the Supreme Seema versus Ashwini Kumar. Ashwini. Seema versus Ashwini Kumar. This case is relevant. The reason is that here actually in this case, the Supreme Court has pointed out that there is one provision in the Constitution, and the provision list 3, entry 30. Here, the provision is for vital statistics. Vital statistics. And now the power is given to the government as well. Power is given to the government, that government may prescribe registration for what purpose? For vital statistics. So this is actually the provision. Now, by taking the help of that provision, here actually the Supreme Court issued the direction to all the states and the union territories that they may make the registration of marriage as compulsory. Now directions were being issued 2006. And what happens after this direction? Some states, they actually accepted this direction, acknowledged it, and implemented it, and made the registration compulsory. But how? But other states, there are so many states, they had not accepted this verdict, and they not implemented it. Now again, in the same case, Seema versus Ashwini, in the same case, here again the Supreme Court pointed out, Supreme Court given the direction for registration of the marriage. Here it was directed to the states who have not implemented that order to implement the order within 3 months. So this case is very important. Seema versus Ashwani Kumar. Here the spelling which was given by one person, the spelling was correct. Ashwani, Ashwani. Ashwani Kumar. Seema versus Ashwani Kumar. Actually in this case, direction was being given by the Supreme Court to all the state and the union territories that they should make registration of marriage compulsory. They should make the registration of marriage compulsory. And some state followed it, some state not followed it. Therefore, 2008, in the same case again, the Supreme Court has directed the state to implement it. So this is the provision of Section 8. I do not want to consume more time because actually this aspect is not very relevant for the LLB students. But the students who are preparing for the competitive examination, this may be asked that what is the fate of this registration of marriage you have the Supreme Court decision also. You may refer it. Any doubt, any person? Any question? May I proceed further? Any question on section 8? Please tell. Any person come out? Oh? Hello?
Yes, sir.
Any doubt? Section 8? Okay. So I am proceeding towards the section 9. And section 9, this is very relevant and very debatable issue that is called as restitution of conjugal right. Here the word is restitution of conjugal right. Conjugal right means husband and wife should live together. This is called as conjugal right. Why the marriage takes place? Marriages takes place under the expectation that husband and wife will live together in future. This is called as conjugal right. And suppose any person means any husband or wife, he withdraw the company of the other. If he or she withdraw the company of the other, then here section 9 provide the provision for restitution. Restitution means restoration. If the conjugal right has not been implemented, has not been followed by the husband and wife, and any husband or wife left the company of other, then the provision is given for restoration of conjugal right. Conjugal right means cohabitation. So now, section 9, if you go through the provision, you can very well say that what is written in section 9, I am just putting before you. If either the husband or the wife has, without reasonable excuse, that is very important. Where any husband or wife, without any reasonable excuse, withdraw this from the society of the others, agree to apply by petition to district court for restitution of conjugal right. This is very important. First part. It means that if either husband or the wife withdraw the company of other without any reasonable excuse, if withdrawing the society, then here the provision is given that the aggrieved party may apply before the district court for restoration or for restitution of this company. Company means the husband or wife who has withdrawn the society, who has withdrawn the company. Under this provision, he will be compelled to join the company of the other spouse. Now, what more written? It is also written here that the court is satisfied with the truthiness of the statement, and the second one, there is no legal ground why the application should not be granted. These are the two grounds. When the court is satisfied regarding the truthiness of the statement in the petition, and the second one, there is no any legal ground why the application should not be granted. If a court is satisfied by both, then the court may pass the decree of restitution of conjugal right. Now, under this decree, actually, the husband and wife who has withdrawn the society without any reasonable excuse, he will be compelled to join the company of the other spouse. Any doubt? Now I am proceeding the explanation which is written. Reasonable excuse means what? What is meaning of reasonable excuse? Reasonable excuse means if there is any reasonable excuse, then this decree will not be granted. But burden of proof of reasonable excuse lies on the party who has withdrawn the society. The explanation is very clear here. What is written in explanation? It is written in the explanation that first thing, one party has to prove what is that other party has withdrawn the society or the company of other. First one, other party has withdrawn the company or the society of first one. And second thing, once it is being established, then the party who has withdrawn the society or company, he has to prove that he has a reasonable cause to withdraw from the society. So this is actually section 9 which is being provided. And now the question is, in modern time, whether section 9 is relevant, because here law commission has also one seminar and also recommended that this section 9 should be repeated. Why? Because actually it is compelling the parties against his or her desires to join the company of the other. Requirement: one party withdraw from the society or the company of the other without any reasonable excuse. The second one, the second part, and in the second part it is written that here that if the court is satisfied, if the court is satisfied that truthness of the statement made therein. And the third one, there is no legal ground that why not the decree should be granted. So if by all respect the court is satisfied, the court may grant the decree. Now I am coming on the first point. What is the meaning of reasonable excuse? This is very debatable, particularly under the section 9. Reasonable excuse means what? Here, by few cases I want to put before you the concept which is given of reasonable excuse. Suppose the wife is under the job, she is job, and suppose she has been transferred from one place to another place. Now, her husband can say that wife has withdrawn the society of the husband without any reasonable cause, excuse. So here we have a line of cases, and one line of cases having the traditional view, and that traditional view is very clear that this is obligatory on the wife, that wife should live with the husband. So this is one view which emerged. The second view, second line of cases we have also, and in this second line of cases, we can very well say that here progressive attitude has been taken also by the court. And here it has been pointed out that if due to the exigencies of the employment, if the wife is being posted in another place, then this cannot be called as wife withdrawing the society of the husband without any reasonable excuse. Both line of cases I will just put before you. So firstly, traditional approach I will put before you. And the case which I want to put before you, the name of the case is Kirat Kaur versus Kripal Singh. Kirat Kaur versus Kripal Singh, this is the decision of 1964 Punjab High Court. Here actually, On the inspiration of the husband, the wife has taken the training of the tailoring. This training was being actually taken by the wife, and actually the husband was instrumental. He inspires the wife that she joined the training of the tailor. After completion of this training, she got the employment. First employment she got on the same place where the husband was there, but later on she was being actually got another employment in another place, which was nearby the residence of the husband. Actually, so long as husband and wife both were convinced, both wanted to run the marriage, so they were meeting together. Sometime husband is spending some time at the wife's residence, and another time similarly also, wife also when got the leave, she spend her time with the husband. So marriage life was very smooth. It was smoothly run. But later on, some some conflict arose, and whatever that may be, but it is not mentioned. But there is some sort of conflict in between two was being actually came out, and now husband compelling the wife to resign from the job and join the company. When she refused, then the husband filed a petition before the Punjab High Court, before the district court, for restitution of conjugal right. The case is very plain, very simple. The case actually gives the reflection that this is actually the temperament of the patriarchy. So long as husband desires, he allowed, and so long as he was not desirous, he was compelling his wife to join him at his residence. Now here the decision which was given, that is very surprising decision. And here actually the book of Mullah was being quoted, and the particular section is being actually quoted, that was 555. And after that, the decision was being given. Here what decision was given? Here it has been pointed out in this case that this is the wife's first duty towards the husband, that to submit herself obedient to the authority of the husband and remain under his roof and protection. This is very important. So now here, traditional approach was being taken by the Punjab High Court, and it has been pointed out that this is obligation of the wife, that wife should live along with the husband. She should submit, she should be obedient to the husband. It means if the husband allowed, no doubt she continued the marriage. If the husband did not allow, she had to resign and join the company of the husband. Now this is the one case. This is the traditional approach. Similarly, also the same approach was being taken in the Madhya Pradesh High Court. The name of case is Gaya versus Bhavoti. Here, it has been pointed out very clearly that ordinarily under the Hindu law, Hindu society, the wife is expected to perform the marital obligation at her husband's residence. This is very important to know. Under Hindu society, this is the custom that wife should be, the wife is expected to perform marital obligation in the husband's house, and therefore she cannot take unilateral decision without the consent of husband to go anywhere. So this is the traditional approach which is taken by the Madhya Pradesh High Court also, and the name of that case is Gaya versus Bhavoti. A similar approach also taken by the Punjab and Haryana High Court. The name of the case is Surinder versus Gurdeep. Similarly, also Kailaswati versus Ayodhya Prasad, Kailaswati versus Ayodhya Prasad. So these are the line of the cases where the court has taken actually the traditional approach, and court is of the view that this is obligatory on the wife, that she should be obedient. She should perform marital obligation at the residence of the husband. It is required under the Hindu society that she should live under the roof and protection of the husband. So this is one line of the cases you can get here. The second line of the cases, this is very important to note, and it is very also a pleasant surprise for our side. Why pleasant surprise? Because of the fact that because of the fact that the why pleasant, because this is actually decision which is given by Allahabad, and the judge, the famous judge Markande Kadju, he has given this judgment, and the name of the case is Santi versus Ramesh. Actually, this case here, the Allahabad High Court has taken very progressive approach, and in this approach, this is the decision of 1971, Shanti versus Ramesh. And here the court has pointed out that if the wife, due to exigencies of the employment, departing from the company of the husband, try to catch my word, if on the exigencies of the employment, if the wife departing, Santi, Ramesh, Ramesh, Romesh. Now, due to exigencies of the employment, if the wife, if yes, Ramesh, this is correct. Now, if the wife withdraw from the society of the husband, and why? Because she had to perform the job. She had to join the job. Here, the approach was that this cannot be called as without a reasonable excuse. No doubt, this is the role of the society. But the second part, without reasonable excuse, we cannot say this is not without reasonable excuse. Here is a reasonable excuse. What reasonable excuse? She had to perform the job. And since she had to perform the job, therefore, when she is actually withdrawing from the society of the husband, then this is clearly laid down by the Allahabad High Court that this is not withdrawal without reasonable cause. So this is a very good approach which is being taken here. But again, there are two judgments where the old notion has been followed, like Andhra Pradesh in 2009. The name of case is Pilli Venkana versus Pilli Nukalamma. So here, this actually conflict goes on. You can not get uniform decision. Somewhere, some high court, they have taken the traditional approach. Sometimes, some high court, they have taken progressive approach. Now, this is debatable one. It is very much debatable. Here, withdrawal of society means what? Withdrawal of society means you can say desertion. Desertion means pagoda. This is a Hindi term which I am using. That one party deserted the company of the other. So when here it is required to prove that one party has deserted. So here desertion not be proved as strongly as in the divorce. But here it is required that it should be established that one party has deserted another party. This is very important. Now, my point is that which approach is correct? Because both are open. Now there is no any decision from the Supreme Court which overruled any of the view. Therefore, both are prevalent. right now in the society. So either you may take one approach or you may take another approach. But I think that most of you will take the liberal approach, progressive approach, and you will be convinced that this approach is very, very much important for the smooth running of the society. But traditional approach is also here. Now we can justify our argument by giving some legal point also, some legislation part also. I just put before you one provision which is provided in Hindu Adoption and Maintenance Act, and that provision is provision of section 28.2. What is written in 28.2? Here actually this provision is relating to maintenance of the wife. First part is very clear, 15.1. Husband is responsible, either party is responsible to pay the maintenance to the other party. Husband is responsible to pay the maintenance to the wife. But 18.2 exceptions are given. Here the wife may live separately and also entitled for maintenance. Here circumstances are enumerated in 18.2. So when our law permits that wife can live separately from husband and also entitled for maintenance, then why not? If due to exigencies or due to requirement of the job, if she is living separately, why it should not be allowed? So this is actually approach which is being actually taken. Now, withdrawal of society, there are also certain examples. And few more examples I want to just put before you. The name of the case is Susila versus Prem, where it has been pointed out that if husband dumped his wife in the father's house and totally showing unresponsible behavior towards the wife, then this is also called as withdrawal from the society. Because under Indian society, what happens? After the marriage, husband mostly left the wife with the fathers, with the mothers, father and mother of their own, not the father and mother of in-laws. So when they are living their wife with the father and by their own fathers and mother, and they became unresponsible towards the wife. It means what? This is also has been clarified and classified that this is a notion which is being actually provided. This is a case of withdrawal from the society. Now, another aspect I want to put before you. Here, withdrawal means withdrawal has a presumption. What presumption? Earlier they were living together, and then one party has withdrawn from the society of the other. This is one of the thing which we are rotating in our mind. But here I want to make clear, very clear. What I want to make clear that earlier cohabitation is not required. If marriage took place, here legal wedlock is required. Legal wedlock means marriage should be valid. And once the marriage has been solemnized, and party is not joining the company of the other, then this case also covered under the section 9. So here, earlier cohabitation is not required for husband and wife. So this notion, if you have in your mind, that withdrawal of society means earlier they should live together. No, there is no requirement that they should live together and withdraw one of the party from the society of the other. What is required? It is only required that there must be a legal marriage. There must be a legal wedlock. If there is a legal wedlock, then naturally it is sufficient for enforcement of this restitution of conjugal right. The name of the case is Venu Gopal versus Lakshmi. This is the Madras High Court decision. Similarly, another thing where consummation of marriage is required for this section 9. Consummation of the marriage, whether required, if the party has not consummated before the marriage took place and marriage has not been consummated and one party has left the company of the other. So whether this plea can be accepted that since marriage has not been consummated, therefore they are free to live apart. No. Here consummation of marriage for this section 9, it is also not essential. So two things be clear in your mind. Very technical issue it is. The first, there is no requirement that parties should cohabit. There is no requirement that parties should cohabit. Before the cohabitation, if marriage takes place and party never cohabited with each other. So if the marriage took place and parties never cohabited and one party is leaving the company of the other party, then this is the institution of conjugal right. Similarly, also consummation of marriage. The consummation of marriage is also not essential for enforcing the section 9. I am coming on the another point, and another point is whether when the parties are living apart under the agreement. Try to understand, there is agreement in between the parties that they want to live and they are desirous to live separately. Suppose there is one agreement. Whether this will be a valid defense when a restitution of conjugal right is being claimed by other party. Try to understand. Suppose the parties entered in agreement. Here, actually try to understand, this is very crucial and very important. And very narrow distinction has been drawn by the court. Court has pointed out that if agreement is a pre-marriage agreement or the agreement is post-marriage agreement and they are agreeing that they will live separately, if they are agreeing that they will live separately, whether this is the motto of or this is the objective of the marriage, whether this is the objective of the marriage, no. What is the objective of the marriage? Objective of the marriage is that the parties should live together. So any agreement, either it may be the pre-marriage agreement. Pre-marriage means before the marriage if the party entered in the agreement, or post-marriage. Post-marriage means after the marriage if the party entered the agreement, and under that agreement they have the clause that they are free to live separately. So here the approach of the court is very clear. What approach was? What approach is? The approach of the court is, this is against the public policy. Why it is against the public policy? Because of the fact that objective of the marriage is that husband and wife live together. And if agreement will be held down, I think that you have studied the contract act. Here contract, under contract, if any agreement has been made which is against the public policy, that agreement will not stand. Similarly here also, this is public policy. Why the marriage takes place? Marriage takes place. Marriage takes place that both the parties should live together. Now, another point which is very important. Suppose there is a valid agreement. Suppose there is a valid agreement. The language which is written, the language is very important. When the parties are living separate under a valid separate agreement. Try to understand, demarcate the difference between pre-agreement, post-agreement, and valid agreement. Pre means before the marriage, post means after the marriage. Valid agreement means, here valid agreement means suppose the parties they are not able to live together peacefully. Then they entered in the agreement that we right now we are starting to live separately. So this is actually justified. This is justified and it is allowed. So this distinction you should have in your mind. This is a very sharp distinction. Pre-marriage agreement, post-marriage agreement, not. But if there is an agreement and after that agreement, why agreement took place? Because the parties were unable to live together. And then they entered into this agreement will be made. Any doubt? This is very sharp distinction. But line is very thin. If you are not able to understand, I can repeat. Please say. Any person come out?
Yes, sir. Please, sir.
What?
This post-marriage agreement and this agreement which is valid and has been done post-marriage.
Now, there are two kinds of things here. Please be clear. Pre-marriage agreement, post-marriage. Pre-marriage agreement means for the marriage. If agreement is in between party, that they will live separately. What is the use of marriage? Post-marriage agreement means marriage took place and they agreed that they will not live together. Then here, the objective of the marriage is that they should live together. And that objective is being defeated. That's why it is called as it is against the public policy. So far as the valid agreement is concerned, why not divorce? Divorce is not very easy. Here, one thing is very clear. So long as marriage has not been solemnized, here the male partner is naturally having in dominant position. He may marry, he may not. But once the marriage is being solemnized, now the female partner is very much dominant. So long is not desirous. It is not possible to get the divorce. So divorce, and once the divorce will be granted, it means tie comes to an end. So in order to save the marriage, if the parties they entered in the agreement, since they are not able to live comfortably, but at least some agreement should be there that they should live separately. Now they feel whether they can continue to live separately. Because when they start to live separately, then they may have desire that company of the other. So that is the actually a test which is being there. So that's why.
But sir, the test of public policy still lies in a valid agreement, which you are saying is a valid agreement.
But sir, I don't understand. Valid agreement means the agreement is made to save the marriage. When we are not comfortable, better entered in agreement that we will not able to live together. Now let us experience. Let us have experience whether we can live without that partner. If you can survive, you may very well having the ground for divorce also mutual consent. You may adopt that, but it will take time. Your divorce is not very easy. Marriage is very easy. So here actually objective is to save the marriage. And in pre-marriage and post-marriage, the objective is to defect the marriage. So that's why this distinction is being drawn. I'm not getting the question. This here. Please come with voice. Who is asking the question?
Sir, if there is a pre-marriage agreement and it is contingent on the condition that the criminal background of husband and his family, then whether it will be valid or not.
No, it is also not valid. It is also not valid. What is the objective after the marriage? Before the marriage, you can do anything. You may, this is your duty, you may make inquiry about the criminal background of the husband or the wife. But once the marriage took place, this is very surprising when I will discuss the divorce case. Chastity of the women. This is one of the important components. Chastity of the women, whether it is required for a valid marriage, approach of the court is very clear. Court has pointed out if any person is very anxious about the chastity of the wife, it is his obligation before the marriage he should make a proper inquiry and then enter in marriage. Are you getting? Tell. Ajit.
Sir, once the court is saying that consummation of marriage is not necessary for Section 9.
For what? For what? For restitution.
Yes, sir.
For restitution, consummation, because here actually objective of the marriage that husband and wife live together.
But sir, this argument of agreement, pre-marriage agreement, is totally based on the objective of marriage, and on the other hand,
no. This is against the objective of marriage, because you are giving the opportunity to the parties that after the marriage they can be free, and this will be actually polluting the society. So here actually it is against the public policy.
Sir, the consummation of marriage not being necessary, can it be against the public policy?
No, consummation of marriage is not essential. Why it should be essential? Suppose after the marriage the wife or husband is not desirous to join the company, whether they will be set free. They will be set free to move in the society. Why they underwent in the marriage, and when they underwent in the marriage, this is their obligation to live together. Are you getting?
Okay, sir. One doubt. The doubt is regarding that the marriage. Okay, if the agreement has been made to protect the marriage, sir, no doubt. But sir, if that agreement goes on and in that case, sir, then what does this agreement is protecting? Because in that case, the very objective of marriage will be violated because the agreement is going on and on and on.
No, but agreement which is no doubt, agreement is made that they want to live separately. This opportunity should be given when they are not in a position to live together. At least this is one opportunity before the divorce. It should be given to the parties. That party should assess themselves whether they can live without the company of the other. If they can live, or they are free, they can proceed for the divorce. Okay? Okay? Now, another word I want to put before you. What is the meaning of this reasonable excuse? We are discussing it. One part I have discussed, that is relating to employment. When the wife is under employment, is under exigencies of the employment, she left the company of the husband. Uniform decisions we are not getting. Another thing also, reasonable excuse. This is the withdrawal of the society. One party withdraw the society or not. Reasonable excuse. Reasonable excuse means, suppose the husband is beating every day to the wife. Whether whether wife can live with such husband. It is not possible. Suppose husband is coming after taking the drink every day. Naturally, the wife will be compelled to leave the company of the husband. This is called as a reasonable excuse. Wife has a reasonable excuse. So now here parameters which are laid down. 3 parameters are laid down, whereby it has been pointed out, and this parameter is actually judicial. By judicial decision, this is not legislative parameters. This parameter is laid down by the judicial. Now, the first parameter laid down, that reasonable excuse means what? Reasonable excuse means where this will exist in a form where the matrimonial relief can be claimed by a party. This is a very technical one. So suppose reasonable excuse means what? Reasonable excuse means the ground which the party is taking. Party means the party who is the company. If on that ground she or he can get matrimonial relief. Matrimonial relief means he or she can get divorce. So this is very important. First one, if the party who has left the company of the other on any of the ground, and that ground is sufficient for getting the matrimonial relief. And if it is sufficient for getting the matrimonial relief, kahan diya hua, that is also very important. Here, ground of divorce is given under section 13. And this is actually called as matrimonial relief. So all the grounds which are mentioned under section 13, these grounds on which matrimonial relief may be claimed: adultery, cruelty, desertion, apostasy, renouncing the word, okay? So unsoundness of mind. These are the grounds which are being given. So suppose one party is guilty of committing that act. Suppose he is very cruel, or one party has deserted earlier. So when he is doing something which is act of the cruelty, then this will be a sufficient ground that other party may file the petition and get the divorce. So this is called as reasonable excuse. If one party withdrawing the company of the other on the ground on which he or she can get the matrimonial relief. Then this is called as reasonable. The second one, where petitioner is guilty of any matrimonial misconduct, and that matrimonial misconduct is not sufficient for getting the matrimonial relief, but it is very weighty and grave. This is also the second ground. Second ground means suppose the party is guilty of any matrimonial misconduct, and when the party is guilty of any matrimonial misconduct, but here matrimonial relief they cannot obtain, it means it is not a ground enumerated in section 13. Under section 13 certain grounds are given. So misconduct is not coming in that ground, but if that misconduct is actually weighty and grave, if it is weighty and grave, then this may also be called as a reasonable excuse. Here I want to give explanation, some example by which you will be able to know. Here there are so many grounds which are adultery, cruelty, desertion, apostasy. Every ground you can get in 13. But one ground is not mentioned. What is that? HIV. Suppose one party is suffering from HIV/AIDS, and you are all knowing well that HIV/AIDS, it is sexually transmitted disease, but it is not mentioned in your there act under section 13. So suppose one party is suffering from that, matrimonial relief cannot be up to, but the party is free. Party is free. Part company of the other party. Why? In order to save himself or herself. If the one party is suffering from HIV/AIDS, then naturally it will be communicated in the body of the others. And the third one, if any of the petitioner who is guilty of act, omission or conduct, and by that act, omission of the conduct, he or she makes it impossible for respondent to live with him. So that act is act, omission or misconduct. Three words are here. Act means कार्य होना चाहिए. There must be some act. Suppose the husband is not having the talking term with the wife. This is the act of the husband. This is called as act. Omission means he is not taking the care of the wife, or the wife is not taking the care of the husband. This is the omission. And the third word, conduct. Suppose one person is doing something which is immoral. Conduct is immoral. Then here, we cannot expect with the other party to live with the first one. So here, three things are being clear. Reasonable excuse means reasonable excuse where matrimonial relief may be obtained. The second one, here, reasonable excuse means we cannot get matrimonial relief, but this is sufficient. This is grave and the weight. And the third one, act, omission or the conduct, when we cannot expect with the party to live with the first party. So we shall continue discussion because it is very technical one. Any person having any doubt? Because time is over. Then a valid agreement, try to understand valid agreement means only formalities are not here explaining. Valid means there must be valid reason for it. If there is a valid reason for an agreement, then the court pointed out, this is the good agreement. If there is no valid reason, then the agreement cannot subsist. Okay, right now, so we are going to disconnect. Tomorrow we shall discuss. See.